If you're involved in commercial litigation, the question you'll be asking yourself is, am I on the most effective pathway to resolution? Am I making the right decisions, taking the right steps to get the best possible outcome? When asking yourself that question, you'll be faced with natural uncertainty. There's uncertainty about the legal process, about the legal outcomes. But you'll also be faced with things that feel uncertain, that feel out of control, that are actually warning signs about whether you are on the most effective pathway. It might be that the cost of the dispute has significantly exceeded what you were told to expect, or it might be that the time you have taken has significantly exceeded what you were told to expect. So how do you tell the difference between uncertainty that you can expect and uncertainty that's a warning sign? I'm going to suggest in this short video a model, a framework for understanding the difference between those two things, and a way to ultimately answer the question, am I on the most effective pathway to resolving my dispute? There's essentially four things to examine. Is it really your dispute? Have you mapped out a clear pathway, a clear strategy for resolving the dispute? Do you understand the risks, and do you understand how you can influence those risks? And finally, do you have certainty around cost? Number one, is it your dispute? Do you understand your objectives? Have you clearly set out what you're trying to achieve from your dispute? And is there a consistent understanding between you and your lawyer about your objectives? It's okay to be uncertain about whether you'll achieve your objectives. It's not okay to be uncertain about what those objectives are. What are your priorities? Have you discussed those priorities? Have you clearly set out what your priorities are for this dispute? For example, it may be a priority for you to preserve the relationship with the person you're in a dispute with. Well, are the steps and behaviours that your lawyers are taking in the dispute consistent with that priority? Do you feel included? Are you receiving regular communication? Do you understand the steps that are being taken and the steps that need to be taken? And more importantly, are you being armed with the information you need to make informed decisions, informed choices, or do you feel like someone else is making those choices for you? Number two, do you have a clear pathway to resolution? Do you and your lawyer have a plan to resolve your dispute? Do you understand the conditions and the timing that will make a resolution more likely? Have you considered alternative ways to resolve your dispute that don't involve a mediation or trial? Do you understand the process, and do you understand how the steps in that process will contribute to making resolution more likely, will contribute to meeting your objectives? And do you understand what's expected of you at each step? If you've tried resolution, if you've been to mediation and it's failed, have you considered alternative ways of resolving your dispute that don't involve going to trial? And if you are going to trial, have you considered whether it will resolve and finalise all of the issues in dispute? Number three, do you understand the risks? If your dispute is left to a court to decide, there is always going to be some uncertainty about the outcome. But it's not okay for you to be uncertain about what a court will rely on to determine your dispute and how you can influence that outcome. What are the three most important questions a court will be required to answer? What information will the court rely on in order to answer those questions? Do you understand the weaknesses in your position? It's okay, indeed it's important, to dwell on the weaknesses in your position. It's not okay to be uncertain about whether those weaknesses exist. And finally, number four, do you have certainty around price and around cost? Do you know what you've spent to date? And do you know what you expect to spend in order to get to resolution? Do you have a basis to be confident in that estimate? Were the estimates you were given on cost previously met, or were they exceeded? What are the risks to future costs? Have you had discussions about how you can contain those costs? Have you had discussions about certainty of price, about fixing price? So what does the right path, the most effective path to resolution look like? Well, it has 4 ingredients. The first is that you understand and are clear about what your objectives are, that there is an agreement between you, your lawyers, and the stakeholders about your objectives and priorities, and that each step in the process is directed at achieving those objectives. Number 2, you have a map. You have a clear pathway to resolution, and that pathway and that map includes all of the alternative options, so that you are never uncertain about what the next step is. Third, you're armed with the information, the advice, the intelligence that you need to make informed decisions about the risks that you face, so that you can make informed decisions about how to deal with those risks, and you can make informed decisions about what an appropriate resolution looks like. And 4, you have some certainty about the investment that's required. You have some comfort that the investment is proportionate to the issues in dispute, and you understand the risks at having those costs increase. If these 4 things are present, then despite the uncertainties you can expect in litigation, then you can be confident you're on the most effective pathway to resolution.